Very warm good evening to all. Today we will be discussing a topic which is actually not a law in our country, but still there is a lot of discussion in our country, that is about prenuptial agreement. That is an agreement before marriage. Now we all know that this is against public policy as a lawyer, but the client still comes to you and they ask you whether we can have prenuptial agreements. The reason behind that, the growing number of divorce, separation, and the maintenance issues, and on the long pendency in the court, which is very, I would say very difficult even for the courts and for lawyers to handle, because the litigation is going every day. Now, what happens when we are going through this court? Just a minute. तुषार light बंद करना, डोळ्यावर जाते. Now, in this growing cases of the divorce and maintenance, the clients also prefer, maybe out of fear, maybe out of their own insecurities, that they should have a prenuptial agreement. Now, when they are speaking about prenuptial agreement, they say that in the foreign country it is allowed. Not in all the foreign countries, but a few of the foreign countries it is allowed. But in our country, it is not allowed. The reason behind, in our country, it is a sacred, I would say, sacred thread between the two persons, not only between two persons, but between the two families. Now, when these two families come together, it is, I would say, though it's in some of the religions, it's a civil contract, as in the Muslim law. In Hindus and mostly other this, it is like coming of together of two families, and when two families come together, the relationship builds, and this relationship does not mean that that they should be guided by the law to have a prenuptial agreements. और बहुत पॉपुलरली बोला जाता है कि हमारे यहाँ शादी करने से पहले, मतलब पहले शादी तोड़ने की बात लिखी नहीं जाती है. So it is that easy to understand. So prenuptial agreements are total complete no, even if the client tells them to make it, it is legally not valid. Now, the another reason, it is against public policy. That is any agreement. If you read the civil law, any agreement which is against the public policy, which is immoral, against the law, cannot be made. So you cannot take away somebody's right even before he or she enters into an agreement of something. So you cannot take away somebody's right. So with consent also, it is next to impossible. And what happens when the parties come to the court, even if one party to the settlement arrived, even if the court agrees, if there is a put one allegation that I have signed only out of force or pressure, then the whole agreement becomes null and void. So prenuptial agreements are complete no-no in our country. If anybody comes and tells that these kinds of agreements are allowed, if it goes to the court, it is not going to stand anywhere. So never ever, first of all, draft this kind of agreements, or never ever advise against this agreement. There is one small exception to this. In state of Goa. Goa is a state which was previously ruled by the Portuguese. Now here, when the marriage is registered in the Goa civil law, there are some provisions there, or as per the law, you have to maintain your assets and the liabilities and everything. The list has to be given. So there is a small thin line there, but that also, it is not that maintained legally that you can call it a prenuptial agreement, because the in Goa, the civil law for marriage is totally different than whole of the country. If you study, this is again a matter of different complete discussion. We will have a different lecture for that, for the state of Goa. But here it is little bit different. Even the Muslims there, they cannot practice the polygamy, so they have to mostly all of the laws, all of the marriages are registered under special marriage act, like that. So they are not guided by the religion there, but guided by the civil law of the Goa. So this is one exception. Otherwise, the prenuptial agreements are complete no-no in our country. Secondly, if somebody comes and say that there is a prenuptial agreement, then what do you do? Now here, what happens if the client comes in person and you have a prenuptial agreement? If both parties agrees, you can always make a consent term in your divorce petition, in your separation, when they go for separation. That things, what was written in the past can be taken, the reference can be taken. But to make the other party agree to same is totally not acceptable. I have one very interesting judgment which I found during research of the Guwahati High Court. I'll be sharing one para from the same, which will throw light whether prenuptial agreements or any kind of agreement, even between the husband and wife, is allowed or not. This is a case from the Guwahati High Court, Bulbuli Saikia versus Jadhav Saikia. Can a husband escape from his liability to pay maintenance to his wife by signing an agreement to the contrary? Guwahati High Court throws light. I'm reading one small para from the judgment, which was observed by the court. And it is again a para from the another judgment. The statutory right of a wife of a maintenance cannot be bartered, done away with, or negative by the husband by setting up an agreement to the contrary. Such an agreement, in addition to it being against public policy, would also be against the clear intendment of this provision. Therefore, giving effect to an agreement which overrides this provision of law, that is section 125 CRPC, would tend to amount to not only giving recognition to something which is opposed to public policy, but would also amount to negation of it. So this was observed in this judgment. So this case, you cannot barter a wife or children, because if they have agreements, it may be for the children who are born from there, they may not inherit the property of the father. So if you're bartering a lady or her children's right, it is against public policy. So prenuptial agreements cannot be allowed. In our country, it is still not allowed. And in the long run also, I don't see it will be allowed. The reason behind, because you cannot decide what is going to happen. And one of the parties who does not agree to this consent terms, which were, I would say, use the word consent term, not a prenuptial agreement. Normally, we use the consent words in the family court when we file cases. Now, if these consent terms or the prenuptial agreements contents is brought before the court and one of the parties I do not agree, then what will happen? Of course, it is against public policy, it will not stand. So this was all about that. Now we move to the another part of the session, that is reading by Komal. This is a trial court judgment from Delhi District Courts. Komal, unmute yourself, please.
Yes, ma'am. Can I start?
Yes, yes.
This appeal is directed against the judgment dated 20th February 2010, passed by learned Metropolitan Magistrate, by which the appellant was convicted under Section 354 of the IPC. By subsequent order on the point of sentence, the appellant was sentenced to undergo rigorous imprisonment for a period of 6 months for the said offence and also to pay fine in the sum of Rs 2,000. In default of payment of fine, the appellant was directed to undergo simple imprisonment for 1 month. The fine was paid by the appellant before learned trial court, and his sentence of imprisonment was suspended till filing of the appeal by the learned trial court. The sentence of imprisonment awarded by learned trial court was further suspended by this court during and until the conclusion of the appeal, which is filed by the appellant, being aggrieved by the impugned judgment of conviction and order on sentence passed by the learned trial court. Prosecution case. The prosecution case against the appellant or convict is that on 12th April 2004 at about 8 a.m. in the servant quarter of the Co-Education Senior Secondary School, Netaji Nagar, which is within the jurisdiction of the police station Sarojini Nagar, appellant or accused assaulted the girl Kumari Rinki with an intention to outrage her modesty. charge and plea of the accused. The prima facie for the offense under Section 354 of IPC was made out against the appellant by learned trial court, and notice under Section 251 of CRPC was framed against appellant accordingly on 26 February 2005, to which appellant pleaded not guilty and claimed trial. In support of its case, prosecution has examined 5 witnesses in all, namely PW1 Assistant Sub-Inspector Nirmala, PW2 Head Constable Sher Singh, PW3 Kumari Rinki, PW4 Srimati Urmila, and PW5 Sub-Inspector Ved Mantar. Plea and defense of the accused. In the statement recorded by learned trial court under Section 313 IPC, the appellant or convict has denied the prosecution case in toto. He has stated that he is innocent and has been falsely implicated in this case. He, however, did not lead any evidence in defense. Arguments and findings. I have heard the learned counsel for the appellant, the learned additional public prosecutor for the respondent or state, and have gone through the trial court record, appeal file, and the relevant provisions of law. The prosecutrix, in a statement recorded before learned trial court as PW3, has supported the prosecution case and has corroborated her statement made before investigating officer, which is ex-PW3A. She and her mother, PW3 Urmila, by corroborated statements, have proved that the prosecutrix had gone to the house of the accused in the neighborhood to give the knife. The appellant or accused, who was chowkidar in the school, had criminal appellant Ladhu Ram versus State, page number 4, pressed her breast. There is nothing in the cross-examination of the prosecutrix and her mother recorded before learned trial court which could discredit their statements in this regard. The learned trial court has properly appreciated the facts of the case and the law applicable to arrive at the correct conclusion as to the guilt of the accused in this case. There is nothing in the statement under Section 313 IPC of the appellant or convict recorded before learned trial court which may discredit the prosecution case. The mere denial of the prosecution case by the appellant or convict in the statement under Section 313 CRPC does not absolve him of the liability in this case. Therefore, I concur with the findings recorded by learned trial court as to the guilt of the appellant or accused under Section 354 IPC in this case. As to the question of sentence, the learned counsel for the appellant or convict has argued that the appellant is an old-aged person about 60 years. He has already faced trial for about 5.5 years before the learned trial court, and there is no likelihood of the appellant or convict indulging any misdemeanor of any similar kind in future. So he should be released on probation or after due domination and may be given the benefit of the provisions of Section 360 CRPC or Probation of Offenders Act. Reliance is placed upon KPS Gill versus State 2005, Criminal Appeal, Ladhu Ram versus State. In KPS Gill's case, the appellant or accused was granted probation on being convicted for the offense under Sections 354 or 509 IPC. He was a senior police officer who outraged the modesty of a woman IAS officer. In that case, the compensation in the sum of rupees 2 lakh was also awarded, which was declined by the complainant IAS woman officer and so was given to a women organization. Apparently, the facts in KPS Gill's case are quite different from the case in hand. Therefore, keeping in view the fact that the appellant or accused has outraged the modesty of a girl, I am not inclined to grant benefit of a domination or probation to the appellant or convict in this case. However, keeping in view the fact that the appellant or convict is an old man of 60 years of age and is stated to be due for retirement in the next month, and has faced trial for about 5.5 years, he deserves some leniency on the question of sentence. The sentence of imprisonment of 6 months awarded by the learned trial court therefore need modification in the given facts and circumstances of the case. instead of the sentence of imprisonment for 6 months. This court is of the view that the appellant or convict should be directed to undergo imprisonment till the rising of the court, and also to pay fine of rupees 3,000 in addition to the fine of rupees 2,000 already ordered by criminal appellant Ladhu Ram versus State, page number 6, Learned Trial Court. Result of appeal. In view of the above discussion, the appeal is partially allowed. The impugned judgment of conviction passed by Learned Trial Court is maintained, but impugned order on sentence passed by Learned Trial Court is modified, and appellant or convict is directed to undergo imprisonment till the rising of the court and pay a fine of rupees 5,000. In default of payment of fine, appellant to undergo simple imprisonment for 6 months. The appellant has already paid fine in the sum of rupees 2,000 before the Learned Trial Court. He shall pay the remaining fine in the sum of rupees 3,000, failing which he be sent to jail to undergo imprisonment in default of payment of fine for a proportionate period of sentence in default of payment of fine awarded to him. The bail bonds furnished in the appeal are cancelled. The trial court record be returned along with a copy of this judgment. The judgment be sent to the server. The appeal file be consigned to the record room.
Thank you so much, Komal. Very well.
Thank you.
Here we saw this is a judgment where the accused was convicted. He was asking for a probation. That is a कहते हैं कि सुधरने की एक मौका. Now, when there is only one offense and the client's age or background or family background can be put before the court, or he is the only earning member, or the offense is done within the family because of some provocation, you can always request for probation under the Probation Offenders Act that the sentence given to him be suspended for a period of 5 years, and if he's throughout that 5 years, if his conduct is good, then the sentence which is given may not be he may not be asked to serve the same. Now, in this case, they have given the example of KPS Gill case, where IAS officer, everybody knows Rupan Deol case, Rupan Bajaj Deol case. In that case, there was a KPS Gill was also a very big person, and here there was a pat from he did a pat on her back, and that was taken as outraging the modesty of that woman, and the case went up to Supreme Court. She was also awarded the compensation. She refused to take. But in this case, there was also a Probation Offenders Act was also asked that he may be given a probation. Now, same thing was applied here, but the court said no. He till rising of court he was convicted, and somehow he was allowed to go, and bail bonds were forfeited. This was the trial court complete judgment to be read by which was read by Komal. Thank you so much, Komal. So if you read judgment, you get so many, I would say, insights. So better start reading one judgment every day. Now we will go to the next part, which is again a very important part about the Hindu Succession Act. Now, whenever a client comes, either it is a 40, 50, 40 to 50% litigation is about the property matters or the family matters. Now, we should be thorough as a lawyer in this kind of matters, because this helps us to understand and give our client good advice. Now, to understand Hindu Succession Act, it is really difficult to take it just in 1 or 10 or 15 minutes, but I'll try to read the important sections. I found something very good for all of you. Now, under Hindu Succession Act, there are class 1, class 2 heirs, and who are they? There is a distribution of property up to date of a Hindu male. Now, for Hindus, testamentary succession, as per the Hindu Succession Act, Indian Succession Act, and the intestate succession without will. There is no will. Then only if there is a will, there is no need to look into the law. How the will, you have to just play the role of the will. Is as per the Hindu Succession Act. In this article, we look in detail the process of distribution of property after death of a Hindu male, as per the Hindu Succession Act. Now, see, class 1 heirs here. The Hindu Succession Act groups the heirs of a male Hindu into 4 categories and lays down that his her inheritable property devolves firstly upon the heirs specified in class 1, which are as under sons, daughters, widow, mother. It is about Hindu male. Son of a predeceased son. It's possible the son may die before father. Daughter of a predeceased son. Son of a predeceased daughter. Daughter of a predeceased daughter. Widow of a predeceased son. Son of a predeceased son of a predeceased son. Daughter of a predeceased son of a predeceased son. Widow of a predeceased son of a predeceased son. Son of a predeceased daughter of a predeceased daughter. Daughter of a deceased daughter of a predeceased daughter. See, it went up to the third level of lineage. Daughter of a predeceased son of a predeceased daughter. Daughter of a predeceased daughter of a predeceased son. This you will understand only when the case comes to you, how it is written. The daughter of a predeceased daughter of a predeceased. Because sometimes the date is totally uncertain. Anytime it may happen. So in these cases, there is a possibility that the Hindu male dies afterwards and his children may die before, but they have the children. They will also have the right. All these heirs inherit simultaneously, and the word is simultaneously. So sons and the daughter of a predeceased son of a predeceased daughter can also inherit simultaneously, and to the exclusion of the other heirs. In the absence of any of the heirs in this category, the property devolves upon the enumerated heirs in class 2. Now see, what is the class 2? The devolution in class 2 heirs is made in the absence of any heir in class 1, and in such manner that heirs specified in a particular entry share equally. For this purpose, if more than one heir is specified in a single entry, they share the property simultaneously and equally to the exclusion of these specified in subsequent entries. Class 2 heirs include father, son's daughter's son, son's daughter's daughter, brother, sister, brother's son, daughter's son, daughter's son's daughter, daughter's daughter, son, daughter's daughter. This can go on, and this you will find everything in the Hindu Succession Act. So I won't be reading completely. Now, another thing you should know, what is agnates and cognates as a lawyer. Now, agnates, in case of Hindu male passes away, intestate, and leaves no class 1 or class 2 heirs, there is a possibility class 1, class 2 heirs में कोई बचा ही नहीं. Then the property would devolve on agnates. A person is said to be an agnate of another. What is agnate? If the two are related by blood or adoption wholly through males. This has to be underlined. If the two are related by blood, either they should be related by blood or adoption wholly through males. Agnate's relationship does not extend to relationship by marriage and is restricted to relationship by blood. Also, agnates does not include widow of the lineal descendant of intestate. This is very important. Now, cognates. And this will apply only when class 1, class 2 heirs are not available. If a Hindu male passes away without a will and has no class 1 or class 2 heirs or agnates, then the succession would be through cognates. Now see, what is cognates? Cognates are one who are related to intestate by blood or adoption, but not wholly through males. It will not be through males. Thus, mother's brother's son, it is the mother's side. Mother's brother's son and brother's daughter's son are cognates eligible for heirship. So this is very important part. Now, all of us know that Hindu succession, there was 1956 and 2005. There was a huge change in the Hindu Succession Act. And what was that? The daughters were also made the co-partner. Daughters was also included. So this is also to be known. So try to read the Hindu Succession Act. It is very deep study. And if you study, definitely there are some, I would say, such kind of matters come which are too, I would, complicated. Now, recently I got a matter where the father-in-law's brother was, he died, his wife also died, and there were no children. So father and father-in-law died, my client's husband also died, and she got 2 sons. Whether they are entitled to this property of her father-in-law's brother. So it is really actually difficult to make out this all the classes, class 1, class 2 heirs. But if you sit down and try to understand, with experience, you will know. So Hindu Succession Act is one act, you should have a very good command over it, because in near future, if there are property disputes which comes up, then this is the best way to solve. And if you can give them the schedule as per Hindu Succession Act, they will also know who are the legal heirs. So it is actually very important act, and try to read, and also try to read is 2005 act, which brought major changes, including the daughters. And daughter become a co-partner. What was the difference? Previous daughters were not included as a co-partner. She could not go for partition. Once she became a co-partner, she can also go for partition. That was the change which was brought by 2005 act, and she got equal rights along with her brother. So this was all about today.